What is a contract? It's a little more complicated than simply paying some money and buying something. There are 10 fundamental things about contract law that you need to know when you enter into any contract. Let's say you pay money and buy something at your local bakery. Is that the extent of your contract? Actually, that's just the tip of the iceberg. And what's important to understand is that all these things are decided at the moment you pay the money at the cashier and enter into that contract. Today, we're going to discuss the 10 things you need to know about contract law, regardless of whether you are buying things at your local market or entering into a multi-million-dollar contract. Hi and welcome back to the channel. In this channel, we talk about everything related to the law in very simple terms. Let's get started. A contract is simply an agreement that can be enforced in a court of law. So what's important to understand is that not all agreements are contracts. While all contracts are agreements, not all agreements are contracts. That's like saying all fingers are not thumbs, but all thumbs are fingers. Let's say your friend promises to help you move house next weekend. You rely on that agreement, but on moving day, they don't show up. Can you sue them? No, because that's just a social promise and not a contract. In contrast, if you hire a moving company and pay them and they don't show up, now that's a contract. There is an agreement, there is consideration paid, there is a legal intention to be bound, so you can enforce it. So a contract isn't just a promise, it's a promise that the law will stand behind. Now, once you have an agreement between the parties, the first thing you need to check is if the parties intended to create a legal relationship. Let's say the agreement is entered into in a domestic setting, like between a husband and a wife. In such a case, the courts will most probably say that the parties did not intend to create a legal relationship. For example, in Balfour versus Balfour, a husband agreed to pay his wife £30 a month for her expenses while he was stationed abroad. When he stopped paying, she sued. But the court said that this was simply a domestic arrangement and did not create a legal contract. But in a commercial setting, say between two companies, the law assumes that you intended to create a legal relationship. For example, in Brussels Lambert versus Australian National Industries, a company's letter of comfort to a bank was held legally binding because it was part of the commercial deal. So the context in which you enter into the agreement matters a lot. Now, this doesn't mean that every agreement you enter into in a domestic situation doesn't constitute a contract. It simply means that there is a higher threshold to prove that you intended to be taken seriously. Every contract needs to have an offer. An offer is an indication of intent by one party to enter into a contract with another. But this must be distinguished from a mere invitation to treat. An invitation to treat is simply an invitation to another person to come forward and make an offer. Let's say you want to sell your old iPhone. You put out a post on your social media saying iPhone 12 for sale for X amount. First come, first serve. That's very clearly an offer because you are saying that you are willing to be bound by those terms. But instead, if you put a post saying thinking about selling my iPhone 12, DM me if you're interested. Now that's very clearly an invitation to treat where you're inviting the other person to come forward and make an offer. For example, in Fisher vs. Bell, a shopkeeper displayed a knife in his window. The law said that displaying the pocket knife with the price tag was just an invitation to treat and not an offer to sell. And in Pharmaceutical Society vs. Boots, the courts held that a pharmacy laid out like a supermarket was not offering items for sale by displaying them on the aisles. The customer putting the items in their basket was the one making the offer, and the store accepted at the checkout. So a valid offer can be made expressly, impliedly, or by conduct. It can be to a person, the whole world, or a class of people. And the offer must be communicated to the other party. Once a valid offer is made, the other party can accept the offer. This acceptance must be absolute, unqualified, and unconditional. And you must communicate your acceptance. Acceptance cannot be done by silence. A case in point was Feldhaus versus Brindley, where an uncle offered to buy a horse from his nephew. He said that if he didn't hear back, he will assume that the nephew accepted. The nephew said nothing. The courts held that there was no acceptance because silence didn't amount to acceptance. But sometimes acceptance can happen through your actions, like using a product or providing a service. In Carlyle versus Carbolic Smoke Ball Company, one of the most famous cases ever, a woman used a smoke ball as instructed by the seller in their advert. The advertisement said that if after consumption someone caught the flu, the seller would provide a reward. The woman caught a flu despite consuming the product, and the court said that the company's ad was a binding offer and the woman's action in consuming the product was acceptance, so she was entitled to the reward. For a contract to be valid under the law, in addition to an offer and acceptance, there must be consideration. Consideration means that something of value must pass between the parties. Consideration can be money, services, goods, or even a promise. In a bakery, the baker provides goods as consideration, whereas you provide money. Now, interestingly, as explained in Chappell vs. Nestle, consideration does not need to be adequate. What this means is that you can offer to sell a land for $1. Although the consideration is severely disproportionate, it would be valid if both parties agreed. Not everyone has the legal right to enter into a contract. Usually, when a natural person attains the age of 18 or maturity, they have the right to enter into a contract. And a registered company, which is also referred to as a non-natural person under the law, also has the right to enter into a contract. So there are three main groups of people who don't have capacity. Number one, minors. Those under the age of 18 generally can't enter into contracts. The only exception to this rule is contracts for necessities like food, lodging, and education. In the case of a necessity, minors can be bound by the contract. Number two, mentally unsound persons. Those who don't have the ability to understand what they were signing cannot enter into the contract. Number three, intoxicated persons. If a person is so drunk that they cannot think straight, they cannot enter into contracts, especially if the other person knew about this drunken status. So yes, you can't trick your drunken friend to buy your old car. The contract that you enter into must not break the law. If it does, it's automatically void under the law. You can't enter into a valid contract to commit a crime, to defraud the government, or to do something immoral. A classic example is Everett vs. Williams, where two robbers agreed to split their loot. One sued the other for his share, but the court said that the contract was for an illegal purpose, so it was void. So in a country where selling certain types of drugs or selling weapons is illegal, entering into such a contract will not be valid. Even if all the things that I have mentioned earlier are satisfied, the contract is not valid if both parties have not truly consented to that contract. For instance, this reality of consent is missing when the consent is based on a mistake. Let's say you agree to buy a used car online. You thought you were buying a red 2019 Toyota Corolla, but the car dealer thought you meant the silver 2020 Corolla he has. You both think there's a deal, but you're talking about different cars. That's a mutual mistake, and it means that there is no real agreement, no meeting of the minds. Also, this can happen due to a misrepresentation. For example, if the salesman lies about a key fact of the product you want to buy, and the lie induces you to purchase that item, when you realize the salesman lied, you can declare the contract void. Real consent might be lacking due to undue influence or duress. This is when you force someone to enter into the contract by exploiting the trust they have on you or by threat. The terms are the rules that the parties are bound by. You can have express rules, which are the rules that both parties have actually spoken about and agreed to, and you can also have implied terms, which are terms that are implied by the law. An example of this is usually the law implies that goods sold must be fit for purpose or of a merchantable quality. So even if the parties don't expressly agree to this, this is a term in the contract. So the sellers can't sell you something that doesn't work. Terms are also broken down into conditions and warranties. Wallis versus Pratt explains that conditions are major and important terms of a contract, and if a condition is breached, the other party can consider the contract invalid. Warranties, on the other hand, are minor terms which are not so important, and breaching them will not terminate the contract. It will simply allow the other party to claim damages. You also have to be aware of exclusion clauses. Exclusion clauses are clauses where one party tries to exclude liability. A classic example is a sign at the entrance of a car park which says that the management does not take responsibility for any damage. One important thing about terms is that they must be communicated and agreed between the parties at the time or before entering into the contract. In the famous case of Ollie vs Marlborough Court, a hotel's disclaimer inside the hotel room did not qualify as a valid term because the guest had already checked in at the reception and entered into the contract. Finally, a contract can be terminated or come to an end for various reasons. These include things like performance, where both parties did what they promised; agreement, where both parties agree to walk away; frustration, where there is something unexpected that happens which neither party is to blame for, which renders the contract useless. In Krell vs Henry, a person paid an advance and booked a hotel room to watch the king's coronation. But the coronation was cancelled. The courts held that the contract between the customer and the hotel was frustrated without any fault of either party. Operation of law, where the law says that the contract stands terminated, like in insolvency of one party, or breach, where one party doesn't do what they agreed to under the contract. Imagine you hire a caterer for your wedding, and the contract says that they will provide food for 200 guests on your wedding day. On your big day, the caterer does not show up. That's a major breach by the caterer. Because of that, you're no longer bound to your side of the deal, which is paying them. The contract is terminated due to the breach, and you can even claim damages. In the event of a breach, there are various remedies that the innocent party can ask for from the courts. These include injunctions, specific performance, and even damages. So let's recap. Number 1, a contract is a legally enforceable agreement. Number 2, intention to enter into a contract matters, and this varies from domestic versus commercial agreements. Number 3, there must be a clear offer to be bound. Number 4, there must be absolute and unqualified acceptance. Number 5, there must be consideration, which is something of value must pass between the parties. Number 6, only people with capacity can enter into a contract. Number 7, the contract must be legal. Number 8, consent by the parties must be genuine. Number 9, there are different types of terms in a contract: express terms, implied terms, conditions, warranties, and exclusion clauses. And number 10, contracts can be terminated for various reasons. Contracts are everywhere, from buying your morning cup of coffee to signing a multi-million-dollar deal. But understanding these 10 points mean you will understand the fundamentals of any contract. Now, I have done deep dives on some of the cases that I have referred to during this episode. You can check them out by clicking the playlist that is on your screen now, or clicking on the link which is on the description below. And if you found this episode useful, please do consider liking the video and subscribing to the channel. I'll see you in the next one. Take care. Bye.